Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Our next case is Turpin versus Charlotte Latin Schools et al. We will hear from the appellant.
Thank you, Mr. Chief Justice, and may it please the court. I'm Chris Edwards, and I represent Doug and Nicole Turpin. This time I'd like to request that I reserve 7 minutes for rebuttal. When a defendant files a Rule 12b-6 motion to dismiss, this court's precedent teaches that the court should view all the facts and take all the inferences in the light most favorable to the plaintiff, and that it should apply this court's no set of facts pleading standard. Recently, in Howell against Cooper, the court clarified what it means to apply the no set of facts pleading standard. That opinion says that to survive a motion to dismiss, the complaint need only state a colorable claim for relief, that it needs to disclose the transactions and occurrences that support the claim sufficient to put the defendant and the trial court on notice of the issues to be proved, and that it need not, on its face, disclose a fatal error, something that would prevent it from stating a claim. Doug and Nicole Turpin's complaint clears those low bars. It tells a story about Charlotte Latin School inviting them to take part in a conversation about the school's culture and curriculum, and then turning and expelling their children when Doug took that invitation up and presented problems with his child's 6th grade class to the school's headmaster. Now, Latin disputes those allegations, and it is free to do so, but it must do so during discovery. At the Rule 12b-6 stage, viewing all the inferences in the light most favorable to the Turpins, the complaint states a claim on which relief can be granted. The trial court dismissed, and the Court of Appeals affirmed the dismissal of that complaint, and those conclusions were error. We ask that this court reverse the Court of Appeals decision and remand the case so that discovery may begin. I'd like to, at this point, take the claims seriatim in the way that we've briefed them. There's a lot to cover, but I want to go through them just one by one, but at any point I welcome the court's questions. I'll start with the breach of contract claim. Pleading a breach of contract is not difficult. All a plaintiff needs to do is identify a contract and then identify the term that was breached. And here, Latin made a binding promise to educate the Turpin's children, and it violated that promise when it expelled them. Now, a lot of the briefing has focused on what I will call Latin's defense, which is that it has the right to expel the children if it determines that the relationship with the parents is irreparable, that it's broken beyond repair. I think both sides agree, at least as that is concerned, that the critical question is whether or not Latin acted in good faith when it made the decision that it was impossible to repair its relationships with the Turpins. Viewing the facts in the light most favorable to the Turpins, though, they have alleged sufficient facts to give rise to the inference of bad faith. You have the early assurances beginning in July of 21 that there would be no retaliation. You then have the Turpins presenting to the board in August of 21, and then immediately thereafter, when Mr. Turpin comes forward and says, hey, here are some problems with my son's 6th grade class, you've got Latin reacting by saying, no, this relationship is broken beyond all repair. And I think
when you say that that's evidence of acting in bad faith, what do you mean by that? Is your position that the language of the contract prohibits acting in bad faith, or are you saying that that's an implied requirement of the contract?
So I think that Latin and we agree that the contract, when you exercise these discretionary terms, there's an implicit obligation of bad faith. And if I can, I think, head where you're going, I'll acknowledge we dismissed the breach of the implied duty of good faith and fair dealing claim, but I don't think that should matter much. And so there are two responses to that that I want to just give some clarity to. First, I think that there are cases from this court, and I apologize for not being able to name them off the top of my head, but I think there are cases from this court that say, look, those two claims are duplicative of one another, and so they're sort of part and parcel. And then I read, and I acknowledge it's it's interpreting Delaware law, but I know the Court of Appeals has interpreted it for our law. Justice Berenger's opinion in the Value Health Systems case, and as I understand the implied duty of good faith and fair dealing, it's basically something that's outside the contractual terms, that you would deprive the other party of the benefit of their bargain. And so here we've got an express term that allows Latin to make this determination. And I think that when Latin makes that determination, like I said, both parties agree that that determination has to be made in good faith. And so here, yes, I think the evidence here that Latin was acting in bad faith is sort of the very quick reversal of course after just a week, maybe 2 weeks after this warm and inviting presentation that Latin allowed the Turpins to take part in, allowed 10 other families to take part in.
So what you've described, if we agreed with you that there's sort of two, there's an implied covenant of good faith and fair dealing, and then there can be an implied contractual requirement of acting in good faith that's not a traditional covenant of good faith and fair dealing. And if we agreed with you about that, you would still agree, though, right, that like all questions of the meaning of a contract is a question of law. So whether or not that term is in fact in the contract would be something that we could consider on 12b-6, because the courts can interpret the contract as a matter of law, and then when we know what the contract requirements are, we can see whether you've pleaded a breach of a provision. Do you agree with that?
I agree with you to a certain extent, Justice States. I agree with you that you could interpret what the provision means and how it should apply. I think, and we use the language of ambiguity, which we took from this court's decision in Galloway, and I think that the contract's ambiguous in the sense that when you look at the facts alleged, I think that there may be reasonable inferences to be drawn either way, and so I think that that's an issue that will require discovery. And so here, at least at the pleading stage, I would think that drawing the inferences in the light most favorable to the Turpins, that should be something, even if the court infers that obligation, then the facts are sufficient to move beyond the pleading stage.
Well, help me understand, though, like what would be I guess it would really be sort of a latent ambiguity that would allow that kind of factual investigation here. When we look at the text of this contract, what is missing that we could learn that would make the court realize we can't just say what the contract means as a matter of law?
I don't know that it's a latent ambiguity. I will confess that there are some parts of Galloway that I don't know, that I don't find very, very easy to apply. But one of the provisions, one of the pieces of discussion in the case is, well, if you know what the contract means, if you know what the terms mean, but you can't figure out how it should apply on these facts, then that's an ambiguity. I do suppose that that's appropriately a latent ambiguity, but that requires factual resolution. And so I think that is the theme that we've argued both below at the trial court and the Court of Appeals, that we need some sort of investigation to determine, what everyone was thinking and what everyone believed and how things sort of shook out on the ground behind the complaint.
Okay, well, that's what I was trying to understand. So what you're saying is we would determine as a matter of law, does that provision exist in the contract? Is there a contractual requirement to act in good faith? Then your position is, if we make that determination, then on the facts that you've alleged, there are fact questions about whether that in fact happened, what people were doing, whether that was in good faith, and that's what gets you past 12b-6. But what I'm trying to figure out is if the question of whether there's a good faith requirement in the contract beyond the implied covenant is something that we decide, or if somehow that's not a question that the court resolves de novo at the 12b-6 stage.
I think that is something that the court would resolve de novo, whether that obligation exists. What I will say is I don't think that Latin's ever disputed that it exists. I don't think Latin's ever parsed the fact that there was a dismissal of the implied covenant claim versus the contract claim. And that's because, I think that those are sort of part and parcel of one another. And so I think the parties generally agree that it exists, and then the question becomes one of fact for discovery, maybe for a trier of fact. Moving beyond,
I guess one last question, and then I'll stop on the contract questions. But it seems to me, so before I came to this court, as a court of appeals judge, I was under the impression that it was sort of the universally accepted doctrine of the state that if a complaint alleges the existence of a valid contract, that in response, for example, in a 12b6 motion, you could attach that contract to the motion to dismiss and say, this contract, although it's not in the four corners of the complaint, the document, it's the complaint in the case, can be considered because it's referenced in the complaint. And so long as the plaintiff doesn't say that's not the contract, as long as there's agreement that is the contract, you can consider it. When I was looking at our jurisprudence, I did not see a Supreme Court case that's ever endorsed that. What's your position on, from this court's perspective, whether that is in fact the law in a 12b6 motion?
I think that it would be, in looking at the Court of Appeals cases, and that's sort of what I'm drawing from, because I think, as you say that, I think at least my recollection is in accord with yours, that I don't think I've seen a Supreme Court case about what it means to be incorporated in. I do think there may be a question about whether or not, do you attach the contract, or are you just really looking at the terms that are alleged to have existed? Because I think those are the integral parts. If we've alleged the existence of a contract and that it created a binding promise to educate, I certainly think you could look at, for example, then the enrollment contract that created that. But the parent-school partnership and whether or not those terms are part of the contract, in particular, the term allowing Latin to expel children based on this good faith determination, I do think that may be beyond what is referenced in and integral to the complaint.
Let me ask you why I wondered this. As I was looking at that case law, it occurred to me that perhaps that's not a good rule to have, because you may, and if you in a complaint say, we entered into a binding contract and the terms of the contract are this, and the defendant breached that term, this term of the contract, that to allow the other party to come in and say, read the contract though and see what it says, that's not true, is really inviting the parties to start fighting over what the contract means, whether that's in fact the contract, which does not seem consistent with the spirit of the pleading requirement. You have to plead the breach of contract, and if in fact that's not what the contract says, that would be something, perhaps an early summary judgment motion where you file an affidavit and say this is what the contract actually says. So what I'm getting at is, should we be endorsing that principle, that we look at the terms of the contract, or should we say what the contract says is what your complaint at this stage alleges the contract says, and it's for past the Rule 12 stage before we dig into, okay, what does it actually look like?
I think there is some wisdom to that, just because I think it's consistent with what this court's described in both Howe and in the Pico case that's cited in Howe. You just have to state a colorable claim for relief under Rule 8, and so as long as we've alleged the breach of contract, the existence of a contract, and the breach of its terms, I do think that should be sufficient to get you to discovery. And if you file a motion for summary judgment on is this a breach of contract, under, at least as I understand the Court of Appeals jurisprudence, I don't know off the top of my head if there's any from this court, but as I understand the Court of Appeals jurisprudence, you would also then be able to move for summary judgment again on different issues. You could still litigate the case, but if that is such an obvious and early issue, then I think an early motion for summary judgment would be an appropriate way to deal with that. And furthermore, I think that you sort of get this merits peak that the no set of facts pleading standard expressly or doesn't contemplate, where you have here a lot of emails, a lot of just traffic back and forth between the parties. And in reading the briefs, a lot of our argument is really about how you should interpret the record that really doesn't exist at a Rule 12b6 stage.
But in this case, you didn't merely allege the existence of a contract and that there was a breach. You actually, in the complaint, included language from, excerpt huge parts of the contract and the parental agreement as well.
The parent-school partnership.
Yeah. Yes.
Yes, Justice Earls. I know.
So why would it be fair to say the plaintiffs can pick and choose which parts of the contract they want to put in the complaint, and the defendants can't say, but wait a minute, you left out this crucial sentence that really actually defeats your claim? Why would that be fair?
So two responses. One, you're right that we did include large swaths of the parent-school partnership, but I don't think that they are as necessary for our breach of contract claim. I think more the breach of contract claim is related to the binding promise contained in the contained in the enrollment contract to educate the children. As far as the parent-school partnership goes, those terms sort of inform, I think they inform the other claims, they inform the expectations. And I think in harmonizing what I've said to Justice Steets in response to your question, it would be one of those situations where I think you could get whatever I'm remembering from law school, where you would call it the res gestae, sort of the overall impression of the term. So I couldn't just exclude a term. But I also don't know that including the whole contract and litigating a defense early on in the case is consistent with this court's case law adopting the no set of facts pleading standard and creating sort of an open court.
Right, but at the 12B6 stage, we are entitled to consider whether the complaint on its face discloses something that defeats a claim, correct?
Yes, Your Honor, you are.
And so I guess my question is, particularly where large parts of the contract and the parental agreement were included in your complaint, why would it be fair to say, well, because you didn't include the phrase that says Charlotte Latinette can unilaterally terminate the enrollment if it determines, certain facts, that we're not allowed to consider that at 12B6?
Two responses to that question, Justice Earls. First, I think that at least here, I do think that considering it's consistent with Rule 8 to say, look, you've alleged the facts, they have included the contract. So even if you're looking at the contract, I think that mixing my answers up, let me go back. First off, I think it's fair to say that under Rule 8, it just requires a notice of the transactions or occurrences. It just requires a colorable claim. And so I think that is consistent with what this court has said about the nature of complaints and the plaintiff being the master of his complaint. Second off, and this is sort of where I was going before I untangled these threads in my head, it is also our view that if you look at the whole complaint and you look at the factual ambiguities in the contract and how it should apply on the facts we've alleged, that we should still prevail because you've got the invitation to a dialogue, the express directive to take future concerns to the administration, and then this sort of rug pull situation after that happens.
And just following up on that first point, which seems to me the one that's so important to the legal question facing this case, is that that the plaintiff is the master of the complaint, is that this idea that you sort of pick and choose when you put your allegations in a complaint applies to everything. So there are countless cases out there, for example, in the negligence context, where someone's been sued for hitting someone with their car and saying you were negligent and I suffered a bunch of injuries. And you read the complaint, it just sounds like a terrible reckless driver hit them, but the person saying, we all know from the police report and all sorts of other things that this person was drunk, that it was the middle of the night and in the dark they stepped out in the middle of the road to try to cross the street, not in a crosswalk, and various things that are going to mean the plaintiff can't possibly recover. And that all has to wait for summary judgment. You read the complaint and you say, these facts, if proven, will state a claim for negligence. And it seems to me that's what I'm struggling with, is why do we have a different rule for contracts than we would for negligence in that pleading standard?
And I completely agree with you, Justice Steets. I think another good example would be the statute of limitations. It's very easy to avoid a statute of limitations defense at 12v6 by just omitting dates. If you file it after the statute of limitations by a couple days, if you file the complaint by a couple days, you just say in this month, and then viewing the facts in the light most favorable to the plaintiff, you sort of assume it's within the statute of limitations, and so that's just an appropriate use of the summary judgment mechanism. So I think that that's exactly right.
If we do think that it's permissible for the defendant to include the contract because it's referenced and quoted extensively in the complaint, I mean, how far do we take that principle? I know you're on the breach claim, but if you look at, for example, the defamation claim, the Court of Appeals relied on language from the presentation that the parents gave, and that, if I remember correctly, was attached to the motion to dismiss.
It was, Your Honor, and I think I want to first start by, and I think I'm going to hear this from my friend, that we haven't disputed that they have attached those. And I think that's more of a desire to avoid having a remand to have just a a motion to dismiss hearing where we may get the same outcome and start the whole thing over again.
Well, my question though was it proper for the Court of Appeals to consider?
I don't think so, because I don't think that the PowerPoint itself, the PowerPoint is mentioned, but it's not integral to the complaint in the same way that, if we say the contract is, it's not integral or mentioned in the same way. It's not quoted extensively. And so, as I understand the Court of Appeals jurisprudence on that issue, no, that PowerPoint should not have been considered. The trial court shouldn't have considered it either.
Well, to sort of follow up on the questions that have been asked, I'm trying to figure out what would the limiting principle be that would say, well, you can consider the contract if it's referenced, but you can't consider other documents that are referenced.
And so I understand the Court of Appeals jurisprudence, and I will get there. I understand the Court of Appeals jurisprudence and our state's jurisprudence a little differently from perhaps like federal jurisprudence, where I think in a federal complaint, if I mention the PowerPoint, I think maybe there's a stronger argument that it should be included. But here, I think it would be, are you quoting from it? Are you drawing from it? Is it sort of the basis of your claim? And here, the PowerPoint is affirmatively not the basis of our claim, other than to say, they have said, other than to say Latin and its headmaster have taken the gist of that and quoted it back to the student body in a false light, quoted it back to the Latin family in a false light.
So it doesn't go to whether you've stated a claim for defamation, it's whether there's a defense.
That's right. I mean, the PowerPoint is itself part and parcel of the truth defense to defamation. I mean, that is, Latin's entire briefing on that point has been the gist of this is true. And so I think that it would be inappropriate, at least at the motion to dismiss stage, to determine whether or not it is true or not based on a PowerPoint without having any discovery surrounding that PowerPoint. Very quickly, I want to jump to the unfair trade practices claim. I know that that's one that some of our amici have weighed in on. It's one I feel that we've stated a strong claim for. First off, the fraud claim is, obviously, the fraud claim would support an unfair trade practices claim. But more than that, I think that we've alleged a pattern of unfairness and conduct that's likely to deceive that should support that claim. There's no dispute that this was inter-affecting commerce among the parties. There's no dispute that it caused the Turpins harm. And so really all that's there is whether or not this is unfair or deceptive. I want to start by addressing Latin's waiver point head on. I think that this is different than Lannan, where the state sort of changed its entire sovereign immunity theory at this court, and instead of saying, oh, the contract needs to be written, it then said, no, this is a governmental function. The statute requires us to impose these fees. And it's different, for example, than Justice Newby's concurrence in Macklemore, where the issue is you've raised sort of this general constitutional due process issue, but not raised this specific issue that the court decided the case on the merits. And here, I think we have raised the specific issue, which is unfairness. The statute prohibits unfairness or deception. And I think there are a lot of different cases from the Court of Appeals, from the Business Court, from this court, from the Fourth Circuit, from district courts talking about what unfairness means and how you think about it. But I've never understood those to be different theories of unfairness as opposed to just different ways to think about whether or not the facts alleged support an unfairness claim. And so here, with regard to the unfairness, we have alleged, Latin invited the conversation. It enticed the Turpins to take future concerns to the board, to the administration. And then we see, I think it's at paragraph 80, where there's this Zoom meeting where Latin has made its position known that, even before we had this August 24th meeting, we thought that what the Refocus Latin folks were doing was awful and tearing the school apart. And so to me, it shows this sort of, they are engaged in this process. They're engaged in this conversation where they don't have any real purpose. They don't intend to listen. They don't intend to participate in good faith. And it's more than just a breach of contract at that point, because you're setting false expectations and you're forcing the Turpins, or you're putting them in a situation where they can't control their own contractual destiny, and you're taking away some of their rights. And so I think that is supportive of our unfair trade practices claim. I see them in my rebuttal time. Unless there are any further questions, I'll save the rest of my time for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice. May it please the court. My name is Jennifer Van Zant, and I'm here on behalf of Charlotte Latin Schools and the individual defendants. It's interesting that my colleague raised the Lannon case because in Lannon, this court talked about waiver. And now, then, the majority of his argument focused on the issue of whether or not the complaint is properly before this court. That's not been briefed. They've always agreed. And if this court seeks to engage on that topic respectfully, it deserves the chance to be briefed fully.
But isn't the problem with that I mean, where every appellate court has to review, it's a question of law, so every appellate court has to review the 12B6 ruling de novo. When we do that, we have to look and say, what are the things that we're allowed to consider? If we said what you're suggesting, which is, well, no party really, argued about this before, so just ignore it, that would essentially be allowing the parties to stipulate what the law is. We don't allow that. So if we conclude we can't consider the complaint, aren't we required when we test the sufficiency of this complaint to answer that question ourselves, that legal question?
And yes, of course, it's up to this court to determine what the law of the state of North Carolina is. That is your province and your obligation. And so the one thing I would say is that, and Your Honor, we too have scoured Supreme Court law because we cite Oberlin Capital, every day, and for the purpose that you can incorporate attached documents that are incorporated. I will say that we've found some relief in the Wells Fargo v. Link case, which is a per curiam affirmance of a business court case that had relied on Oberlin Capital. So there is that in terms of precedent. But in terms
one doctrinal question, so you've made me feel comfortable that at least you're familiar with the same case law that I am. So let me ask you just a couple of doctrinal questions. So one question I had is, what would happen if a defendant filed a Rule 12b6 motion in a breach of contract case, attached the contract, and then the plaintiffs said, that's not the contract? I'm assuming that what would happen is that the court would then say, all right, this has got to wait for summary judgment. Would you agree with that?
I would, Your Honor.
And then, so my question is just doctrinally, if that doesn't happen, so you attach the contract, isn't that what essentially is happening, is that the plaintiff is acknowledging, I agree, that is in fact a contract, which is to say stipulating to this fact, and then the court's considering that. And traditionally, even if it's just a stipulation of a fact, we would say, well, the matter, if that's being considered by the court, has now been converted to a Rule 56 summary judgment proceeding, because once you're considering the actual facts, not just the allegations, it's summary judgment. So how do I fit this together in my mind to say this precedent needs to stay the way it is?
And so I think that, Your Honor, I think it goes to what Justice Earls was pointing out, I believe, is that when one party quotes partially from a contract, it's just inherently unfair and inefficient to go just on those facts. And respectfully, I think it is different than, one party's description of an accident and failing to reveal that the light was red, for example, because the contract is known and definite in almost every situation. And so here, especially here, where we have a breach of contract claim, and this court, Justice Sharp, in the Cantrell case, said you have to identify the provision of the contract that was breached. And here, they don't. They don't identify the provision of the contract. The court, to fully address the question on 12b6, to determine whether there are facts that defeat the claim necessarily as a matter of law, which is still the law as part of the 12b6 standard, needs the whole contract. And so it was appropriate.
Yeah, so let me try to restate that, because I'm just wondering if maybe we could just ignore the attachments to your 12b6 motion if we determined that in the allegations of what this contract says, there's no allegation of an express good faith requirement, the implied covenant of good faith and fair dealing claim has been dismissed. So it hasn't pleaded a breach of contract based on some violation of good faith. I mean, that is something we could look at 12b6 without ever getting into what attachments we are looking at and that sort of thing, right?
I would wholeheartedly support that result. If the court were to determine that the complaint on its face does not adequately allege a breach of contract, even without looking at the contract. They don't point to a particular provision in the contract. The complaint invokes due process rights that don't exist. This is a private school. And so you could find that there was not an adequately pled breach of contract on the face. Your Honor, if I might, I'm going to go to the unfair and deceptive trade practices claim, and then I'll come back to the other claims. The issue before the court today is the nature of the relationship between a private school and parents. And the answer is it's an arm's length contractual relationship to be governed by the same contract laws and same tort principles as any other business in the state. Here we have parties who could not agree on the direction of a school, its curriculum, and its policies. They could not agree and they separated. That's a natural result from a contractual relationship. But what it isn't is an unfair and deceptive trade practices claim. The challenge facing the plaintiffs is this court has had almost 50 years with this kind of claim to develop precedent, and that precedent leaves no room. Absent a statute deeming something to be a UDTPA, there are three possible routes to a claim. One, an underlying tort such as fraud. We've addressed those in our brief, and I can touch on them. A breach of contract with aggravating circumstances, or a standalone unfair or deceptive act. Now, the plaintiff is arguing that here we have an unfair or deceptive act that supports this claim. And we need to remember, of course, that this court has held repeatedly that even an intentional breach of contract is not a UDTPA claim. The Court of Appeals has found that concealing an intent to breach does not support a UDTPA claim. Holding otherwise would transform every alleged intentional breach of contract claim into an unfair and deceptive trade practices. Now here, and further, plaintiff's formulation of generic deception or unfairness, we don't like the result standard, would swallow the aggravating circumstances approach to UDTPA. Plaintiffs do not cite any cases where a breach of contract was found by this court to amount to a standalone unfair and deceptive trade practice claim without fraud or negligent misrepresentation. There's discussion, but there's not an actual finding. And as this court said, and I know you have this cited to you all the time in bumpers, in most cases there is nothing unfair or deceptive about freely entering into a transaction on the open market. Here, the parties exercised their right to contract, and they entered into an agreement which established a method for termination. Plaintiffs seek to modify that contract, a contract no one contends is unfair on its face, to give them rights they did not bargain for. That result undermines the import of contract and gives a free pass to a party that didn't like the result of its bargain.
Do you agree that the two contracts, the enrollment contract and the parent-school partnership, those documents taken together invite a parent to share with the administration concerns?
Absolutely, Your Honor. The parent-school partnership, which is incorporated into the contract, has expectations, and the expectation does indicate that parents may have, there's an expectation that parents may communicate. Of course, the parent-school partnership also expressly reserves the termination right. So that we have two things. We have an expectation and we have a right, and those are different. But here...
So it goes on to say that after asking a parent to register comments and concerns, it says that the school will clearly define and communicate standards of behavior, which I assume would also include what they expect from parents. As it says, parent behavioral expectations are covered in the document, but it says that the parents and the school will model civility, integrity, and good sportsmanship. And then it goes on to say treating one another with mutual respect, courtesy, and dignity. Would you agree that that seems to indicate that the school will proceed in good faith under this contract?
Your Honor, again, that section is talking about expectations. The termination provision is a discretionary right, and we conceded in our briefing that it may not be invoked with a pretext or bad faith. But here, the complaint tells us that after the presentation in August, the participants of the presentation were told, thank you. We're not going to engage on these topics further. And yet Mr. Turpin persisted. He emailed on August 29th, raising all the same issues and to the same group.
Is that not a fact issue?
Well, I think, Your Honor, that does get into our earlier conversation. It's incorporated into the complaint, but
Well, but whether this was a new incident that he reached out regarding one of his children and the concerns that that child had indicated, like not removing his mask to drink water, how is that a continuation of anything? And even if we were to say it is, why is that not a fact issue?
So, Your Honor, the complaint pleads that Mr. Turpin reached out in the email, and then there was a meeting, and the complaint pleads that he did nothing at the meeting that would give rise to a reason to terminate. So there was no reliance on that email because he didn't do anything. He doesn't plead any reliance, and of course reliance would need to be pled with particularity. And so again, we do know that he raised issues about his child, but he also raised the same issues he had raised repeatedly, bringing up the same failure of DEI, political topics, and wokeness.
Aren't you asking us to delve into factual matters? Because the way I read the complaint, there was just one meeting where the parents of this particular viewpoint expressed their views, thinking that there would be no retaliation for their having expressed those views. And then, again, looking at the complaint in the light most favorable to the plaintiff, there's an incident at school where the child's not able to drink, and some other matters that are raised. I know you're characterizing that as continually. How do we as a court, when we look at the complaint, say, well, yeah, okay, it's continually?
So, I mean, respectfully, Your Honor, you could decide it was a breach of contract, but why would it? It's not an unfair and deceptive trade practices act violation. I mean, and
if we were to say this contract required good faith, fair dealing, and that there in the contract is a safe space for a parent to convey to school administration their concerns, and then despite that there is retaliation, why does that not get to an unfair or deceptive act?
well, because retaliation is when you do something and there's an unrelated consequence. And so if I fail to pay my rent and then my lease is terminated, that's not retaliation, that's a direct consequence. And here, Mr. Turpin repeatedly made clear that he was not happy with the direction of the school, despite having known it before he signed his enrollment agreement.
So where is the repeatedly made clear? That's the point of my question.
Mm-hmm.
And if we go beyond the contract or the complaint, why doesn't this get us beyond a 12B6?
Well, so that I think that goes back to our Oberlin Capital dispute already. So, but before the
So where's the repeatedly made clear?
in outside the documents, Your Honor, or inside the documents? Because inside the documents, he talks about this issue is not going away. I'm happy with this.
You're talking about emails,
Yes, Your Honor.
but not the contract itself.
Right, that's correct. I'm unhappy with this agenda. Parents are in the unenviable position of having to rethink whether Latin's the right choice for them. Alumni are not going to be giving their money, and he is pushing and pushing and pushing. And the issue is whether Latin, in good faith, decided that the contract was that a positive collaborative relationship was impossible, and the complaint never pleads that wasn't triggered. They never say that they acted, that Latin didn't reach that conclusion. We also, again, we have to have reliance if there's deception, and there's no reliance. Mr. Turpin made his last rounds of complaint in the September 7th email, and then there were no more complaints. The complaint stakes their reliance on an alleged statement made by the board chair that no one will be retaliated, but then the complaint itself goes on to allege just 3 paragraphs later, in paragraph 63, that after the presentation, the parents were told that the board and administrators were not going to continue to engage on those topics, thus ending any assurances. So even if it's pled, and it's not, it would not be reasonable as a matter of law to decide that the statement made before the meeting was carte blanche to continue to raise the same meetings. But
Can I ask you a quick clarifying question? Did I hear you say that you read Oberlin Capital to say you can consider not just the contract, but email correspondence and presentations and other things like that?
I would apologize, Your Honor. Oberlin Capital and its progeny say that if documents are the subject of the complaint, then they may be considered on a 12B6 notice.
Okay. But Oberlin Capital itself was a contract case, and it said the contract. Right?
It was, Your Honor. Apologize.
And everything I've talked to you about, it becomes a very slippery slope if any written document referenced in the complaint, you can do the same thing. I mean, at that point, you're just inviting arguments about that's not the email, that's not what I said, and all those sorts of things. A contract, at least, the idea is, in the mine run case, the parties can say, yeah, that's it. It's not a fake or something.
And the documents here were more than referred to, though. They were quoted from. So, in the briefing.
Sorry, but to go back to
Thank you.
the defamation claim.
Yes, sir.
Am I right in thinking that the COA relied on the presentation and its analysis of why, in its view, the defamation claims fail?
The Court of Appeals did, Your Honor, but there's an alternative basis that we argued, which is that the challenge statements were not of and concerning the defendants, and that does not require consideration of the PowerPoint. That you can look at the statements themselves, and from those statements, it's clear that there's no mention of there being the Turpins. There's no mention of there actually being about the Refocus Latin presentation directly itself. And so if this court should decide not to rely on the PowerPoint presentation itself, it can still address the defamation claim and affirm based on that the challenge statements were not of and concerning the defendants.
Wouldn't the fact that the children were removed direct the attention of the people at the school back to the Turpins?
I don't believe, Your Honor, that the complaint pleads that that fact was well known, that the children were removed. So I don't know that would be in there too. I mean, it's an element of the claim that they have to plead that it was of and concerning the defendants. And respectfully, we contend that they did not plead that. So here, Latin, of course, is not a public school, and by choosing a private education, the Turpins both gained and forsook. They exercised their rights, and in doing so, they gave up some rights and freedoms by entering into a contract. That's what a contract is. More than 100 years ago, this court recognized that sometimes a private school just needs to separate from people who refuse to adhere to its policies. In Teeter v. Horner Mill, this court said, the interest of every pupil is involved in the welfare of the school, and there's no reason why its success should be imperiled by the misconduct of one of them. Plaintiffs' amici urged this court to expand UDTPA to extend protection to private school parents, but the freedom to contract gives them the protection they need. Applying unfair trade practices liability in this case, a contract dispute does not promote transparency or accountability in private education. Rather, it would force judges into the business of regulating private schools. It would create statutory liability and business risk that neither private schools nor the numerous families could allocate through contract. If a private school cannot exercise its contractual right to end a relationship without fear of tort liability, then private schools would turn into vanilla, one-size-fits-all experiences that avoid offending everyone and end up pleasing no one. Plaintiffs' amici provide no help in boundaries, they say that disagreements over dress code would never be as important as disagreements over curriculum. But it doesn't take a lot of imagination to envision someone coming into a private school, objecting to rules on modest dress, raising the issue repeatedly, and threatening not to go away. Expansion of UDTPA to cover a subsequent contractually authorized separation would turn every complaint at a private school into a potential tort minefield. Such expansion is not only unwise, it's unneeded. And there's no reason to expect that such intrusion would stop at private schools. No company should be forced to do business with a customer who refuses to accept the terms and conditions of that business, least of all a private school. Allowing plaintiff's UDTPA claim would subject every business that terminates a contract to a similar claim. Now, if private schools start abusing their contracts, parents will vote with their feet. The marketplace will adjust. Private school parents are consumers like everyone else, and like everyone else, they're protected by the contracts they enter into, particularly where they knew about the curriculum before the contract was signed. The Court of Appeals properly affirmed dismissal of the UDTPA claim.
I'm sorry.
Thank you.
Obviously, I'm stuck on defamation, but as I understand it, there's a slander claim and there's a libel claim.
Yes.
And the slander claim arises from comments that were made during Mr. Turpin's meeting with the head of school and the head of middle school. Your argument that, well, this wasn't widely known, that wouldn't apply to that claim, would it? Because wasn't your comment directed toward the email that went out? That's a separate defamation claim, isn't it? Or am I confused?
It was a separate defamation claim. The libel claim is actually against Latin administration and all the volunteer members of the board. And the slander claim is more limited. But my comment, respectfully, was directed toward the concept of, did the statements identify the Turpins? And so Justice Newby was asking me, well, you know, the children were removed, and then we have this statement coming out later. and wouldn't that, I think where he was going was, wouldn't that tip everyone off that this was related to the Turpin? And so that was my response, Your Honor, was that the statement wasn't broadly, the fact of the removal wasn't broadcast further.
But obviously, there was no doubt in the meeting that between Mr. Turpin and the head of school and head of middle school that the comment was directed at Mr. Turpin.
Yes, Your Honor.
That allegedly defamatory statement, right?
Yes, Your Honor, but of course, a statement made in the meeting wouldn't support a slander claim. It has to be repeated outward because it would have to be published. I mean, you don't.
How many people do you have to say it to?
Your Honor, we didn't brief that, and so I don't want to. But if my colleague and I were in a conversation and I said something untrue about him to him,
Right,
then that wouldn't be.
But if there were a third person there.
Well, perhaps, but the two people there were the administrators.
If there's a third person there, is that not publication or?
But if they were also part of the administration, I don't know that it would be, Your Honor, because it's a part of the same group. Is there anything further on defamation?
No, thank you.
Thank you. So misrepresentation, we briefed that thoroughly. The misrepresentation alleged in the complaint is about the email exchange on September 8th, 2021. It doesn't relate to any previous representations. And so there was, as I discussed, no reliance on that statement. Negligent infliction of emotional distress. The North Carolina law is clear that you have to have a negligent act to support a negligent infliction of emotional distress claim. And here, there is no negligent act. And an intentional act can lead to a claim of negligence, but that is not the same as here, where the underlying tort is alleged is an intentional tort, which of course would get us into intentional infliction of emotional distress, which has a different set of standards that are not applicable here. Furthermore, there's a lack of foreseeability. There's precedent, North Carolina precedent, is that just being someone's mother does not give rise to such a tort. So absent both a negligent act and foreseeability, that claim fails. The claim of negligent supervision is similarly deficient because the Walters case from 1913 talks about that a defect or a bad habit is of no effect if the injury complained of wasn't brought about by that defect. And here, there's not sufficient legal nexus between a disagreement on a policy and then the alleged torts. There was also no indication that Mr. Baldecki was dangerous in any way, and so that claim fails. I've talked about the contract claim. If the court could affirm without looking at the actual contract, the court could also affirm looking at the actual contract, enforcing it as written, and construing it as a matter of law, looking at the difference between the expectations and the right. And the complaint tells us that Mr. Turpin knew the relationship was impossible, saying, "I think many parents are now in the previously unthinkable position of having to determine whether Latin has left them," and to again and again bringing up that what he wanted was an apolitical education for his children. The Turpins come before this court with a parade of horribles about what will happen if their claims are not allowed to proceed, but Latin's not seeking immunity or elevated standards. It is asking that this court recognize that the relationship between parents and private schools is grounded in contract. Application of long-held, clear North Carolina law regarding tort liability and straightforward interpretation of a contract leads to the inevitable conclusion that the Court of Appeals appropriately affirmed the trial court's ruling, and we ask that this court affirm that decision. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
I know you've got things to say in rebuttal, but to save me some time,
Please.
Justice Allen has now made me have a question. So on the defamation, I thought, and so rather than me going back and searching, if you could just tell me in the complaint, I thought your client expressly alleged that Baldecchi said those things to your client in the meeting and then went and published the same defamatory statement to the members of the board, and that was the publication. Am I remembering that wrong?
So, no, I don't think you are. I think, two things. One, Baldecchi and Mr. Balaban were in the meeting, and so at least as to a personal defamation claim, nobody's briefed, nobody's contended that it's sort of this like intercorporate immunity issue that I think Ms. Van Zandt raised, but at least personally, as between Baldecchi and Balaban, I think that that's sufficient publication. Moreover, that is, you're correct, the only way that the school would have found out, that the board would have found out about the expulsion. I want to talk, to your point, Justice Allen, about the mention. I think my friend on the other side said there's no mention of the presentation. Paragraph 194 of the complaint, that quotes from the email that went out. It specifically mentions the presentation. And this is a per quad claim. It's not a per se claim, and so it doesn't have to be obvious on the face of the statement. We need discovery to figure out what the import of the statement was, and I think the per quad nature of it differentiates it from a lot of the cases we cite. Moreover, as far as the of and concerning issue, I don't think that's an alternative basis. There were 10 parents who presented at this meeting. I think refocus Latin, I don't know that there's any limitation on the rule in Carter v. King, but in our brief we differentiate between saying, maybe it's a bad example given the small nature, but a justice of the Supreme Court versus all the justices of the Supreme Court. And I think that those are meaningful distinctions. One would be not of and concerning anyone, and one is of and concerning everyone. And so I think that's what we've alleged, that latter type, where it's everyone in refocus Latin. I want to circle back to some of the conversations that Chief Justice Newby and Justice Steets, you had with Ms. Van Zandt about the attachments to the complaint. I think there's more than one way to read those emails. I mean, there is a difference in me saying, hey, this isn't going to go away. You should probably address this head on, and I'm not letting this go away. And Latin is reading it the second way, which is inappropriate on a Rule 12b6 motion. I completely agree with Chief Justice Newby's point that it's not entirely clear to me, how this becomes a second or a repeated incident. You've got a parent sending a follow-up email, and then you've got a parent sending another email that raises completely separate concerns. And maybe they are, maybe they're not related, but I think the degree of interrelation and whatnot, I think that's a question of fact. And I think that that's something that the conscience of the community, the jury, needs to figure out at the end of the day. Because, those are, I'll admit it, I mean, those statements are the issues in the case are charged. And so I think somebody needs to figure out whether or not Mr. Turpin was being overbearing or whether or not Mr. Turpin was being a concerned parent. Turning to the contract claim, we do allege a breach of the specific terms of the contract. Paragraphs 208 and 210 in the complaint. 210 actually has a quote in it that Latin promised, it's a binding promise to educate the children. I don't know that we are required to anticipate and allege Latin's defenses, which is sort of the gist I'm getting from Latin's argument. But even if that were the case, if Chief Justice Newby, to your point, if you think that the contract and all of the expectations import some sort of good faith obligation, then I think that that's a fact question and it goes to discovery. And if not, if the contract is clear and it's sort of in itself has some good faith obligation, then also that becomes a fact question. The UDTPA claim, that is, it's not. I think the Latin's argument about that claim stems from its view of the facts. From our perspective, this is, hey, please have this conversation with me, and then sort of an immediate about face. And so it's not really something that a contract protects against. I mean, it's one of those things that I think the FTC Act, sort of going back to the purposes of Chapter 75, you want to encourage honesty and forthrightness between consumers and businesses. And here, I think Latin is not displaying that. So that the answer to, is this going to convert every breach of contract into an unfair trade practices claim, is just be honest. You know, if you don't want me to talk about these issues, tell me. Tell me that, and that again goes to the facts. You know, we've alleged that Ms. O'Leary said, don't talk about the issues in the PowerPoint. I think there is more than one way to interpret that. Finally, I hear my friend on the other side to, I think, concede that that intentional conduct could give rise to a negligent infliction claim. But again, the second issue then is it foreseeable? It's not just the parent relationship. And this is a multi-factor test as outlined in Newman, as outlined in Sorrells and in Johnson. And it's, you know, the very essence of a multi-factor test is the need for discovery and the need for development to determine what is and what is not foreseeable. If there are no other questions, we ask that the court reverse and remand. Thank you.
Thank you, counsel. Start